Good morning.
Good morning. Allison Renfro for the appellant, Jeffrey Smith. I'd like to reserve 3 minutes for rebuttal.
3 minutes? Yes.
May it please the court. The two issues before the court today are whether the trial court abused its discretion when it awarded sole decision-making to the mother and whether the father should be awarded his attorney fees on appeal. In this case, the trial court modified the parenting plan to increase father's parenting time, repeatedly praised the parties' communication and co-parenting, scolded the mother's treatment of the father. She was cussing in front of the child and had the dad arrested in front of the child during the litigation, yet awarded the mother sole decision-making authority. We submit that this is an illogical decision as the trial court failed to consider applicable law and applicable statutes when reaching this decision. The applicable statutes are 366407 and 366106. The court found that 366407B, factor 3, favored the mother, which was an illogical result. That factor says one parent is opposed to mutual decision-making, and such opposition is reasonable in light of the party's inability to satisfy the criteria for mutual decision-making. Yet the evidence in the record, as reflected in the court's order, is that the parents were communicating well and were co-parenting. The court complimented the parties on their communications, which it referred to as insightful, gracious, blew the court away, that there was a lot of good there, that the court stated twice that it was thoroughly impressed with how the parties were communicating, and that the parties had a propensity to do a great job with respect to this child and was thoroughly impressed.
In analyzing that factor specifically, though, whether or not sole decision-making was on the table, the court seemed to really be concerned about this March 2024 incident involving the father's arrest. I mean, that's one of the things the court specifically mentions when it ultimately concludes that this, I mean, the way the court put it is this factor favors mother, not so much that it's a reasonable decision, but how did that factor in? I mean, what are the circumstances behind that event in March of 2024?
Yes, so there was an exchange of the child. The father was with his mother. The biological mother came out, started cussing at the paternal grandmother. The father stepped between them, and then the mother said, "You're going to jail. I'm calling the police," called the cops. The child was crying, wanting to go with the father. Those were the circumstances. And the court did scold mother for that, said it was totally unacceptable. She got really out there. Yet the court gave her sole decision-making, which is what we're saying is the logical result. And while we're talking about that, Justice McBride, you delivered the opinion in the Thompson v. Thompson case of November 2024 that changed decision-making from sole to joint when a sole decision-making parent did not demonstrate an ability to cooperate with the other parent. And Thompson decision instructs us that not cooperating with the other parent, you don't then award that parent with sole decision-making. You remove their sole decision-making and make it joint. But that's not what the court did here. There's this parent acting badly, and she gets sole decision-making. We say that's an illogical result.
But didn't the court find that both parents, I don't want to say acted badly, but had conflicts with the other, and at some point the court's got to make a decision, can the two work together? Or if not, then I have to pick one, and sometimes the best choice is not always available. Isn't that what we have here?
The court found that the communications did get snarky at times, and both parents got their shots at each other. But that brings me to another case, the case of Gutierrez v. Baggett that you, Justice Clements, joined in November of 2023 that affirmed designating a sole decision maker when the parents were unable to co-parent and the inability to make joint decisions was detrimental to the child. But that wasn't the case here. Their disagreements had to do with scheduling appointments. There was no proof in the record that their inability to make decisions was detrimental to this child. In fact, the biggest situation in the record was about homebound care, whether the child needed to sit at home for 30 days recovering from surgery and be tutored, or if he could try to go to school for a little bit while he recovered. The mother was adamant that he needed to stay home, and she forged ahead, contacting the teachers and the doctor without including the father, even though they had joint decision making, and then gets really mad that he just doesn't agree with her on the spot, that he wants a chance to talk to the doctors and the teachers to see what's going on. And once he has an opportunity to talk to them, they rally the troops at an IUP meeting and they decide, oh yeah, he can go to school part-time. And that was a better outcome for this child. And that included the father in the decision making, not just letting mom call the shots.
Well, I mean, the way I read that, though, is that the father prioritized socialization over perhaps another issue. I mean, to me, yeah, you could say, well, the educators ultimately found that the child could be educated in a school setting rather than home education. But I mean, there would be advantages to the home, right, because of the care and attention that the child gets in the home setting, right?
There could be advantages, but if there's a chance that the child could recover and go to school, that seemed like a better outcome.
Well, I mean, is it fair to say that the findings here support that there's a history of disagreement of the parents about what's appropriate medical care, health care for this child?
No, the main disagreements, as noted in the court's order, was scheduling appointments. Mother would schedule appointments, father would find out through the MyVandy app or after the fact. He'd get frustrated, and then there was one time where he rescheduled an appointment, and mother saying he should lose all decision-making authority because he rescheduled an appointment, or he should lose all decision-making authority because he got a little snarky with me. If that's the case, we would have no joint decision-makers.
So in your position is your client is not so much disagreeing to the care, he just wants to be present for when the care takes place.
He was present when the care took place via video a lot of the time. The disagreements didn't often go to the heart of the care, except for that homebound issue. And the parties entered into a parenting plan in October of 2022, and we'd submit that was a less drastic alternative than just removing his decision-making altogether. That parenting plan, which the court adopted in its order, has multiple paragraphs of how to care for this child, how to defer to the medical professionals, the equipment that is necessary, the medications that are necessary. So if the dad wasn't giving him medicine or was delaying care.
I mean, what I'm reading in part from the court's order here is sort of an undercurrent that the specialists that the child required in many instances didn't allow for sort of the advance notice or the scheduling that would be necessary so that both parents could participate. I mean, that's sort of what I'm reading between the lines in the court's order. Am I missing something, or am I misreading what the court is trying to say there?
Well, the court noted that the medical, I guess, getting medicine in this day and age is not a user-friendly process a lot of the time, but often what would happen is, as we all know, when you're in an appointment, the follow-up appointment is given, and you don't really have an option. They just say, well, the doctor...
Because if you don't take it, it's going to be
gone.
6 months away.
Yes, but what the dad was asking was that she tell him, not that he check the Vandy app on a Saturday and see, oh my gosh, he's got an appointment tomorrow.
Well, and it does look like the court anticipated the father's concern there, where it basically order admonishes mother, hey, you've got to inform father when you're doing this. But I mean, I see here good reason perhaps to pick one parent over the other to make these decisions, at least in terms of scheduling.
Perhaps for scheduling, but not for the heart of the care, whether he should be removed from school for 30 days. I mean, that's a pretty big deal, maybe for appointments, but that's minor. Their disagreement.
Isn't the trial court looking at a circumstance here, though, where mom is sort of the leading figure in terms of care, the one that's most updated, is most on top of what's going on with this child, and that's why mom is better positioned to make these decisions that have to be made?
The trial court said that factor favored mom slightly, the history of participation. Mom's the primary residential parent, but if the court just defaults the primary residential parent always gets to make the sole decisions, then that's not fair. There's
a lot of medical complexity, though, in this case, right? I mean, this child has a lot going on that that requires significant medical attention. I mean, this is a child who has greater needs.
Yes, though the evidence in the record shows that the dad was at most appointments virtually and attended many of the therapies, and so he was involved. And for the court to say that the geographical proximity, and to the extent it affects their ability to make timely decisions, favored mother, there was no findings of facts, no reasons why. The record shows that in app close, the parties responded instantaneous, sometimes 30-plus messages a day. They were communicating instantly about this child's care.
So how far apart do the parents live?
The mother at this time lived in Rutherford County and dad was in Sumner County. The court in Reeves in 2013 said that...
Of course, after yesterday, that seemed Rutherford County is seeming farther and farther away all the time. Yeah.
Yes, got my Rutherford County colleagues here chuckling. That's true, but these parties communicate instantly through app close. And if the father's present in these appointments, either virtually or personally, then the geographical proximity is not
so
relevant.
do all the appointments typically happen within Davidson County? So both parents are having to travel in, or do most of it happen in Sumner, or where are they happening?
The majority of the appointments and
should
therapies are Davidson and Rutherford primarily.
Davidson and Rutherford, okay.
Yes.
Where father lives.
Yes.
Okay.
Yes, so we would show that not in this record, there was nothing in these decisions that were detrimental to the child. The parenting plan had many provisions so that there was less drastic alternatives to removing this father's decision-making. And the case law supports a decision that the father would retain his decision-making. In the Gutteritz v. Baggett case of 2023, the court found factor 2 favored mom, but in this case, it showed that the parents were equal. In that case, there was many issues of the dad not giving medicine and being confrontational with the medical providers, and that wasn't the case here. This father didn't put the child in harm's way, and the child received what we submit as better care when he was involved in the decisions.
All right, thank you, Ms. Renfro. Good morning.
Good morning, Your Honors. Michelle Hauser for the appellee, Ms. Lawrence, here before you today. Your Honor, I think my adversary has done a good job of explaining what the factual, the facts behind this particular case. This is more of a factual type of decision made by the trial court, which, as this court is aptly knows, is ultimately given a presumption of correctness absent some type of abuse of discretion. What was left out of my adversary's argument was that mother has 2 special needs children, not just one.
Including, 2 with this child, so she has one other.
She has one other that also has special needs. She has been the primary person to take care of these children. In fact, she was on medical leave at the time of the trial because of the children's needs at that time. Father works part-time. He stated as an Uber driver or Uber Eats driver so that he could have the availability to attend the child's appointments, etc. However, Father also testified that most of the time he attends those things virtually. He wasn't attending them in person. There were a few that he attended in person, but he didn't attend them other than virtually. The child's nurse, who is with the child for 40 to 50 hours a week, because she attends school with him, testified that she had never seen Father at the school other than one field trip that he attended, and even then, she had to intervene because of.
At the start of this, it looked like the parties were on their way to doing what courts hope parties do, which is mediating a parenting plan. And then things got upset with this emergency petition that mother filed.
Yeah, that was before I became involved in this case. That was when mother was represented by different counsel, and he advised her to go file a pro se. According to my client, he advised her to go file a pro se petition because there was an emergency with regard to the child's care, and the parties could not come to an agreement.
I mean, without getting any too much detail here, could you just tell me what the nature of that emergency was that necessitated this? Sounds like you perhaps disagreed that there was an emergency here.
I don't think necessarily it was an emergency, but it's very easy for me to say that when I sit on this side of a table and we have a parent here who thinks that, because they do have a child with special needs and one little thing goes wrong, it could be catastrophic. I think from her perspective, it was more of an emergency. The court ultimately, I'm not really certain of all of the facts.
The court seems to reference, we've taken care of this problem, or words to that effect in its order. I mean, can you enlighten the court on what that problem was?
Well, I am not certain about what the problem was. I will be honest with the court because, like I said, I wasn't involved in that, and that was a completely different file. It was ultimately treated as a dependency and neglect. And so the court had a probable cause hearing and ultimately found probable cause that the child was dependent and neglected as to the father. But then mother ultimately non-suited that case. So it was a completely separate case from this particular case because it was a dependency neglect.
Would you agree then in the assessment that we really don't worry about that at all, then in the overall scheme of things about the decision-making here?
I agree.
At least that's what the court doesn't seem to pin any of its decision-making on those events.
I agree.
Okay. So let's get to the actual order here. I mean, the court is fairly detailed when going over the 106 best interest factors, but then things sort of taper off when we get to the analysis of 407. And of course, that's important here because that's the sole issue. We're talking about decision-making. And rather than factual findings, the court finds that a factor favors mother. I mean, how is that sufficient for us to review this?
I believe it is. I believe it is.
How should we read that? If a court, court says that if something favors one parent over another, I mean, what does that actually mean when it comes to weighing a factor?
I guess it could mean different things to different people, but to me what that says...
Well, that's what I'm worried about.
Yeah, to me what it says is that the evidence ultimately favored mother. That's what it ultimately says to me. Now, I will say that based upon my adversary's argument, that the interesting part of 407B, especially with regard to the elements of that, is that we have to look to the history of participation of each parent in decision-making in each of the following areas. And that is ultimately why I think the court did not change anything with regard to religion and extracurricular, because they did have some ability to co-parent. The problem became when it came to this child's health, and father was not participating. Mother had asked him numerous times to help with regard to some of the teen care issues. He did not do that. There was this one incident that happened in March of 2024, and the facts were disputed between the parties, as you can imagine. My client said that Mr. Smith, the appellant, pushed her, and then that's when she said, "That's it, you're going to jail. You can't treat me like that." So there was a disagreement there with regard to that. But the history of participation of each parent in decision-making in each of the following areas: physical care, emotional stability, intellectual and moral development, health, education, extracurricular activities, and religion. And what the court ultimately found is that mother being the primary person to make these decisions. She was the one that was interacting with the nurse that follows this child on a daily basis. Father had never talked to this nurse, not once.
So the court says the parties have to be on top of the child's medical care, is one of the things. And so is the implication there that the father was not on top of the child's
He
medical?
was not.
Okay.
And that was by the nurse's testimony.
Well,
She's-
then the court goes on and says, we cannot have this clash on what needs to be done, but as I understand the father's position here, there really wasn't a clash on what needs to be done, except, I guess, in the instance of the homebound schooling, but it was just a clash on, hey, I want to know in advance on appointments. I mean, what does this record show us on that?
Okay, so the record would ultimately.
Clashes.
Okay, the record would ultimately show that there was a clash with regard to the child's surgery. There is some animosity between the paternal grandmother and my client. The paternal grandmother at one time had custody of this child many, many years ago, and so there has been this tug of war between the two of them. Mother had asked father not to have his mother participate in these doctor's appointments. Father would bring her anyway. There was another clash with regard to eyeglasses. This child has some pretty severe sight problems. The doctor ordered a certain type of eyeglasses. Father didn't want to get those particular eyeglasses, so he took him to one of these, I guess, mall type of based places to get eyeglasses. And ultimately that put him behind the scope because TennCare, with regard to covering those, has specific criteria, and it was causing problems for mom to get the actual eyeglasses that had been prescribed to him. There were other instances to where the paternal grandmother became very defensive, and there was a clash between mother and the paternal grandmother in the doctor's offices because the mother asked that the grandmother not be there. There was a big clash with regard to that. There was a clash with regard to his medications and braces because the father was not administering those medications and braces, and that is also in the record.
That the father was not administering? Okay.
That's correct. That's correct. And then even the nurse testified that with the one time that she did see father interact with a child at a extracurricular activity or a field trip, that father did not bring water for the child, which is very, very important for his oral dysphagia. He also was not paying attention to the child's gait because the child was becoming very tired. She also testified that she had to redirect him with regard to getting the child to eat because this child has some very severe difficulties with chewing and swallowing, etc.
Counsel, in terms of the conflict in this case, it seems like the trial court is attributing fault equally with regard to the emergence of this conflict. I mean, we're sort of hearing a litany of father did this thing wrong and father did that thing wrong, but the trial court seemed to have more of a sense that really both parents are contributing to this fight. Is the impetus here this relationship has broken down and we need faster decision making rather than father at fault with regard to the conflict?
Correct. Because that was one of the issues with this whole issue of father taking appointments and rescheduling them. Because as my adversary stated, most of the time, because this child is vastly covered by TennCare, those providers are the ones that are making those appointments. It's not mother who's making those particular appointments based upon what the child needs. Plus, she's having to also juggle another child who has special needs. So when father would reschedule these appointments, it completely set everything up on its ear because mother's schedule is so very tight and compacted. Father's schedule is not tight and compacted. And I would also like to point out to you, Your Honors, that just by this particular order from the trial court does not keep father from participating in the child's medical care. He can still attend the doctor's appointments. He can still attend virtually or however he wishes to do. It's just with regard to those particular decisions because there is a distance between mother and father. And he's up in the Sumner-Gallatin area, and we're down in Rutherford County, Murfreesboro. and most of these providers are in either Rutherford County or in Davidson County. Now, I will say that most of the providers with regard to his therapies are all in Rutherford County. And Father even testified that he doesn't go to those
One of
particular
Father's
therapies.
concerns here was lack of notice, not being informed about appointments. Has the trial court's order brought clarity in terms of what Mother's obligations are with regard to keeping Father informed so that he can be informed about what's going on with his child's?
Yes, yes. In fact, the court said we're going to use App Close, which is a app that's designed to help parents co-parent with each other better, that instead of using the Vandy app or these other apps that also notify the parent that Mother was responsible for placing that into the App Close app, so that he's not having to check several different apps based upon the different providers. Your Honor, there's also the subject of attorney's fees here, and I know that opposing counsel hasn't addressed that yet, but I will go ahead and just take a short time here to talk about that, because my client, as I stated earlier, she's of very limited means. She's on medical leave because of the children's particular medical leave. This is not easy for her to be able to do this, and she had to bring this because the father in this particular situation was being very unreasonable when it came to this homebound. Father kept saying, well, I want to talk to the teachers. Well, he never talked to the nurse. The nurse was the one that was following him around all day.
But here you've only requested attorney's fees under the frivolous appeal statute.
That's correct.
Okay.
That's correct.
I mean, I would find it hard to say this type of appeal is frivolous. It seems like the father's made some fairly decent points about the joint decision-making decision here, if for no other reason, a concern over what's contained in the court's order and the lack of specific findings with respect to the factors. So doesn't that sort of rule out frivolous appeal?
I believe it could, yes, absolutely. That's for you all to decide. I'm going to let you all make those decisions. Your Honor, my client did not want to bring this particular lawsuit against the father, but she felt like she had no other choice. She was up against a wall. The continuous problems that they were having with regard to the most important aspect for this particular child was the health care and the educational decisions. Father did attend the IEP meetings, but he never went to the school, very rarely. The nurse said that she had not seen him one time. But he was upset because Mother was trying to put the child's physical needs first, and Father wanted to put his socialization skills needs first. I mean, that's where the communication broke down. They still share joint decision with regard to extracurriculars and religion because, as the court aptly stated, they did have the ability to communicate well. And that's what's a little, maybe it's a little confusing to me, because my adversary's position is that that Mother was not cooperating, but then we also have the argument that they were having all of these, great conversations. I think when it came to the medical and the educational decisions, that's where the court ultimately found that the child's best interests were not being served by the facts and by watching and seeing the demeanor of the witnesses and the testimony that was presented.
All right, thank you, Ms. Hauser.
Thank you.
Ms. Rodenfro?
First, I'd like to discuss the findings for 36-6407, and that just to state that they favor mom is insufficient, and that findings of fact and conclusions of law under the rules of civil procedure are needed here, and we need to remand this case with instructions to the trial court to make those proper findings of facts and conclusions of law, and remand to the trial court to modify it, to change it back to joint. Why does the geographic favor mom when the evidence at trial showed that they were communicating instantaneously? Why does it slightly favor mom that she had the history of decision-making, but not list out each of the items? And why would you give her sole decision-making when the court explicitly found that the parties have demonstrated the ability and desire to cooperate with each other in decision-making?
Now, in your briefing, you did not ask, I mean, you just asked for an outright reversal, not a remand for additional findings of fact. I know you take issue with the factual findings in the order, but that's not relief that you ask us for.
That is not, as the discussions evolved
Until right
today.
now, yeah.
It was apparent that that is necessary.
Yeah, okay.
So I would like to point that out, that just saying it favors one parent, that would be confusing for the court down the road if that's the standard that these orders are gonna have. The court said we cannot have a clash, but what's the clash? The clash was that the dad wouldn't get appointment notifications timely. And so is that just grounds to remove his parental rights, remove his decision-making authority? We would submit not. When the order states that mother should give him reasonable notice, that in itself is still not clear enough. Why couldn't it?
Does it matter in this case that the trial court seems to have this understanding of the parents as essentially equally at fault in terms of this clash with regard to the decision to change medical decision-making, or does that matter? I mean, does the existence of a clash in of itself lead to making it appropriate to consider, hey, this is a child who has very intense medical needs and you need quicker decision-making, and we do have a clash? Does it matter who's at fault for that clash, or does it not matter who's at fault for that clash?
In the case law, it is apparent that it's relevant who is causing the issues. In the Gutierrez v. Baggett case, the dad was the one delaying the care, going around mother's decision-making with medicine and that sort of thing, and that's why his decision-making got revoked. But when they're on...
Is that why you pointed out the Gutierrez case? Okay, because fault, you think that stands for the proposition that fault finding is important?
Fault finding, and who is making decisions or doing things that are detrimental to the child. In that case, it was the father. In this case, the father wasn't acting.
Well, but to Judge Usman's point, it sounds like in this case the court was finding both, and so you've got to in that case, when you feel like in the child's interest, which is what we're supposed to be looking here, rapid decisions have to be made, and the parties will sometimes rightly or wrongly get into it. The court's got to make some choice. You can't just say if the fault lies equally, well, I can never order sole decision maker, or is that what you're arguing?
Well, but I'm arguing that the clashes were minor and not to the heart of care. When the homebound issue came up, the dad didn't agree on the spot with the mom, but within a day or two, a decision was made, and so the child wasn't at risk of harm. It wasn't to his detriment. It just wasn't, I'm not just I want to talk to the doctor too. And that's really reasonable.
So, counsel, in your view, that's an isolated incident in terms of any kind of serious education, medical related decision making is the homebound education for that 30-day time period?
Yes, the rest were about scheduling appointments.
All right. Thank you, Ms. Renfro and Ms. Hauser, for your arguments. We'll take your case under advisement.